We are back on Morning Line. Thanks for joining us. Our guest, David Raybin, for our final segment here, talking about the governor's executive order, mask mandates, and the like. Before we get to something called police powers or the like that apply here, that David's got the documentation on, let's take a call from Chris real quickly and let him, since he waited through the break. Chris, good morning. Hi, Chris.
How's it going? Great show.
Good. What's on your mind?
Well, my point, basically, the way I read state law is that the governor has the right to overrule locals in matters that are beyond local control. We have our own local health department. So does Memphis. We have our local under control. That's just my point. That's why I think this lawsuit wouldn't go anywhere, because of that state law.
Okay. David, what do you think?
Well, he makes a good point. The question is whether the state law and the governor's action can get at what is a mask mandate, which is not a law that Metro enacts. For example, Metro can enact a law regarding
like an ordinance.
An ordinance or something about how fast you can drive or something like that, or smog emissions and that kind of thing, and the governor could clearly come in and say, well, you're not going to have any more emissions testing in Nashville, because that is a state ordinance. This is not an ordinance. The school board is not acting as a legislature. They are creating a policy to run their schools the way they have the right to do, which state law gives them that authority to do. So the question then becomes, does the governor have the right to preempt the school board in matters of policy, which is not a law per se?
Okay, real quickly, because I have another question, kind of unrelated to this before we wrap it up, but you were mentioning to me about the police powers. Is that what it is?
Yes, this 1905 case talked about the police powers of the government. Now, we're not talking about the police like Metro officers and that kind of thing. This is the right of the government to police itself, to enact regulations of health and safety, that sort of thing, quarantine laws. And the Supreme Court said the police power of a state must be held to embrace the reasonable regulations directly by the legislative enactment as will protect the public health and the public safety. That is a constitutional doctrine that the states enjoy under our federal system. And the locals, as a subordinate agency of government, also enjoys the police power. So the question then becomes, can the governor interfere with the police powers of a local agency to regulate health and safety, not smog and emission controls and that kind of thing, which are clearly ordinances and laws? Is the mask mandate the kind of law that the governor can preempt? That is something the court may have to decide, because that's not crystal clear.
Interesting. All right. I wanted to just shift gears on this, a story I've been following the past week or so. Case out of Bedford County, and I'm going to talk in general because you may not be up to speed completely on that, but is there a circumstance whereby a judge would ever preside over some type of legal proceeding, whether it's a felony, misdemeanor, or anything, of his or her own son?
No. Theoretically, the judge could actually do that, I suppose. They would have a lawful authority, but it would be legally unethical. There is a code of judicial conduct that said you cannot preside over immediate relatives where you have a direct personal interest. The judge could be sanctioned by the court of the judiciary and theoretically even impeached by the legislature. I mean, that is grossly improper. It creates an intolerable conflict of interest. No judge that I know of would ever preside over their own relatives, immediate relatives' case. They would just recuse themselves.
Even if it's something minor, like with regard to a traffic ticket or seatbelt violation?
No violation of the law is minor. If you have to pay even a $10 fine, then you have been sanctioned and it carries consequences. It's an adjudication against you by the state, and the court is acting on behalf of the state when they adjudicate that. You cannot have a judge adjudicating his or her own child's case, whether it's a $10 fine or murder.
Oh, gotcha. Okay, that was quick, and I just wanted that explained on that front with that regard.
It's unethical.
Listen, with regard to other cases you've handled, is there anything else happening with the Andrew Delkey case?
The Andrew Delkey case, for now, has been resolved. We reached an agreement on that. Still a lot of controversy about that. We stand by our decision that was the appropriate decision for our client. He made that decision, and that matter should be deemed to be at an end at this point. That was part of the reason why I think it was resolved, so that there could be some finality. Otherwise, it would have just dragged on forever. I think it was unfortunate that we didn't get a change of venue in the case. I've always maintained, because of all of the hue and cry going on and everything, that the case should not have been in Davidson County. It created an unfair situation.
Had a change of venue been granted, do you think there's a chance it would have gone to trial?
I'm convinced of it, because we wouldn't have had the push and pull of the political thing, the posturing. All the studies that we did in the case, all the reviews that we did, suggested that the city was polarized, some for guilt and some for innocent, and those decisions had already been made beforehand by many people. So it's unfair for either side, I would contend, to go into a trial where you have that strong opinion on it. That's what changes of venue are all about. So if you bring in a different jury that doesn't have those things. Look, we had the case, what was in Dixon, right, the next door case. We had 2 changes of venue within 6 months of each other. Both of them were homicide cases where the police officer was killed, and they brought in a different jury from Knoxville, where the young boy's body was missing. They brought in, yes, they brought in a jury from Chattanooga. They had a trial. A verdict was rendered in both cases, and you didn't have the local people having to make decisions about their own community in a case of that kind of magnitude. Now, that's what changes of venue are all about.
And so, yeah, the point being, of course, when there was a deal that was reached, both sides have to agree to this. I mean, if the prosecution had come to you and say, we're going to offer this, and it just was something that you and your client did not want to accept, you didn't have to.
No.
So you're saying it would have been your call, too, if you accept the plea with your client or not. And had you had a change of venue, because I know your goal always is to get your client acquitted.
Of course.
As it stands, right now he's sitting behind bars, and that was part of the deal. But you would have said, hey, change of venue, I think let's go to trial.
Well, the dynamics of the case would have been much different, because anytime you consider, this is not just his case, but it's any case, you weigh all the risks and factors of whatever might be going on with the case. What are the chances of a conviction or an acquittal, and if so, what? The dynamics, the equation is different, where you would have an outside jury. Then the equation might fall in favor of having a trial with an outside jury, because you might have a more unbiased decision. But where the statistics show that half the community, I mean, look, we already voted on this with the community oversight. The county had already ruled on this in many ways. The vote changed dramatically after this particular case. So I suggest that a change of venue, that's what it's for. You know, but that decision was made. He'll be under the plea agreement. He'll be out in 18 months. There'll be no probation. There'll be no parole. He'll just walk out of there. It'll be done. And I think that was in his best interest. He decided, his and his family.
David, thank you for coming on.
You're very welcome.
We will talk again soon, my friend. We'll take a break. Programming note right after this.